Good afternoon, everyone. My name is Jeremy Herman. It's great to be back with you on this clearly very sunny day, cold but sunny. Um, this is the first live stream that I'm doing this year, 2026. I've hosted many of these Q&A sessions in the past. I'm excited to be back to answer all of your employment law questions live. So don't be shy. Please feel free to post questions, and I'll get to as many of them as I can in the time that we have. As I normally like to do, I want to explain a little bit about our firm. So, if for those of you who don't know us, you're new to us. We are an employment law firm and disability law firm. We are across Canada. We have offices all across Canada, and our goal is to help educate as many Canadians as possible about their employment and disability law rights. And to help as many Canadians as possible with all of those issues. So, contact us. You can find all of our information and a wealth of resources online. Just check out employmentlawyer.ca, and again, you can reach out to us at help@employmentlawyer.ca, and we will be sure to arrange a call with you, with one of our lawyers or legal representatives, and get your issues addressed as quickly as possible. So while we wait for questions, I like to start off with a topic that is trending, and this topic that I'm going to start off with is really severance packages, and what happens when a company. We got notice that a large company called BlackRock is eliminating dozens of positions. So in that situation, what happens? Are employees entitled to severance? How much? So simply the answer is absolutely. If a company is laying off a mass amount of people at once, it doesn't change the fact that each of the employees is entitled to severance. And even if it's financially burdensome for the employer to pay out that much severance, it doesn't change your entitlement to it. And also, what we tend to see, I certainly see it a lot in my legal practice when there is a situation of a mass layoff, is an employer taking a very cookie cutter, similar approach to all of the severance packages that they offer employees. They could even offer employees the identical package, or even if it's not identical, the approach taken is clearly one that is not contextual. They're not giving each employee what their particular entitlements are. They're offering them a very generic package. And of course, the issue with that is that each employee situation truly is different. And you do have to take into account the context. You have to take into account that employee's particular circumstances. One employee could work for a company for 30 years and another one can work for 5 years. And one could be 65 and one could be 35. And these types of employees, they have very different severance entitlements. They're both entitled to severance and probably more than they think they're entitled to. But the reality is that an employer cannot treat those two individuals, those two employees that they're terminating, the same way. And so don't assume that if your employer's letting you go, that what they're offering you is adequate. Almost always it is not adequate. They're offering you far too little. And so you want to ensure that you get checked out by a lawyer at our team. You want to get that letter sent to us. Send us all the relevant information. We like to see your termination letter if you have one, your employment contract if you have one, some pay stubs, and then we'll get a good sense of what your situation was, how long you've been employed, and what your entitlements would be upon termination. So don't be shy. Send us your details. Contact us at help@employmentlawyer.ca, and we will be sure to help you with your severance packages. Okay, so let us start off with some questions we have here. We have a question on Reddit from Sky. I provided medical documentation requesting modified duties, but my employer says it's too inconvenient. Do they have to accommodate me? Yes. If you're medical professional, doctor, whatever actually the case might be, sends a proper document outlining the fact that you need an accommodation at work, and you promptly provide that to your employer, your employer has to comply with it, and they have to accommodate you. So your employer cannot just say something is too inconvenient. The human rights laws across the country are very clear that even if potentially an accommodation is inconvenient, that does not change the fact that you have to be accommodated. The threshold for an employer having to accommodate an employee is very, very high. It's called undue hardship. So it has to be that the employer would suffer really, truly hardship if they were to implement the accommodation that an employee is seeking. And if there isn't really that hardship, even if it's just an inconvenience for the employer, that is not going to be enough for the employer to reject implementing the accommodation. So great question to start us off there. I see these kinds of issues all the time. And don't think that if your employer says something is too difficult for them, that is actually accurate and that the law would agree. Often the law will say, well, that's not a good enough reason. So contact us if you're facing any of these situations, and we'll be sure to help. Okay, another great question we have from Henry on Facebook. I was laid off temporarily, but it's been months with no recall. At what point does this become a termination? Okay, great question. So what I want everyone to understand is that if you're laid off temporarily, assume that you've been terminated effective immediately. It's not a question of when does it become a termination. You have been terminated. There might be particular circumstances where you might have an employment contract that allows the employer to lay you off temporarily, or there might be some large history of layoffs where it's happened so many times, and then this is the time where you want to challenge it. In those circumstances, potentially the layoff is permissible, but almost always a layoff is not going to be permissible, and it's going to be what we call a constructive dismissal. A constructive dismissal is where your employer is not sending you a termination letter. They're not saying you're being terminated. What they're saying is that they're going to change significantly key terms of your employment in a way that you don't consent to. So in this case, a temporary layoff, well, what are they changing? Well, they're telling you that you can't come to work. You can't do your work. You can't get paid. So those are obviously very key terms of employment, that you work and you get paid for your work. And so if your employer is telling you that you can't do that, that is what we call a constructive dismissal. You don't have to wait a certain amount of time to pursue it. You should contact us immediately. And in fact, you want to pursue this kind of case even faster than you would any other case potentially, because you want to show that you've challenged that temporary layoff as quickly as possible. So it does not look like you maybe consented to it or condoned the layoff. But even if you haven't challenged it right away, it's been some time, like you said, Henry, it's been a couple months. That's fine. Still contact us and we'll be able to challenge the layoff for you. I will want to look at your documentation. As I mentioned, your employment contract. I'll ask you, about the history of your employment. Have you been laid off before? And things of that nature. In the rare circumstance that the employer is permitted to lay you off temporarily, it cannot last forever. So Henry is touching on something. It could only last for a certain amount of time. And, in Ontario, that's going to be either a 13-week or a 35-week period. So it depends on whether your employer is continuing some benefits during the temporary layoff. You may not be getting paid, but perhaps you are getting your health and dental benefits. So if you're getting your health and dental benefits, the employer can lay you off for up to 35 weeks. But again, that's only a situation where the layoff is permissible just for a certain amount of time. In most cases, the layoff is not permissible at all. And so you don't have to wait 13 weeks. You don't have to wait 35 weeks. You can challenge that layoff immediately. I've dealt with, I don't even know how many cases like that. They're not complicated at all. So don't sit on that, and give us a shout, and we'll be happy to assist you. Okay, great question, Henry. If you do have a follow-up, of course, feel free to post it in the chat. Okay. We have a question from Garrett on YouTube. If employer hires a permanent replacement for you while you're on a sick leave, is that the same as being fired? Okay. So, I mean, we see these kinds of issues fairly often where, you worked in a certain position, obviously, and you had to take a sick leave, and the employer still needs the position to be filled. They need the work to be done. So it's fine if they go and fill that position. But what you have to understand is that if you're taking a proper leave, then you have a right to your position. So the law says that you have a right to be reinstated into your position. And if the position does not exist, you have to be reinstated into a similar comparable position. So it doesn't necessarily mean you're being fired. It could mean that you're being fired if you come back from your leave, that is, a protected leave, and you don't have that position available. Then yes, perhaps you can absolutely pursue that as a termination. And there's various things that can be done in order to potentially even get that job back, to be reinstated into the job. And if that's not possible, then we could probably arrange a severance package for you. The fact that the employer has put someone in the position, at least for the time being, is not necessarily a termination, though. We have to see what happens when you're done your leave, what the employer does then. That's really the key time frame. Are they giving you your position back, or are they saying, look, we like this other employee, so we're going to keep them in the position, and you don't have a position available? Or they might say to you that we have a position available for you, but it's very, very different than what you were doing. And then that also could be treated as a termination. So great question there, Garrett. Let's see what else we have here. We have a question from Curtis on YouTube. My employer keeps suggesting I should retire. I feel like I'm being forced out. What are my options? Well, don't retire. And unfortunately, this is fairly common as well. Employers will put pressure. The reason why they're doing that is because if you retire, you're resigning. And if you resign, you're not entitled to severance. So an employer will try to put pressure on an employee if they really kind of want that employee gone, but they don't want to be on the hook for paying a significant severance package. So they'll put pressure on the employee to leave and resign their position. And then employer can say, oh, I'm off the hook because I didn't terminate you. You left on your own accord. Well, don't succumb to that pressure. And if it really is amounting to pretty significant pressure, you can actually treat the pressure as a termination itself and pursue your severance pay anyway. So, if this is happening in writing, usually it won't happen in writing. Employers, will kind of slip it in conversations. Well, so when are you planning to, Curtis, when are you planning to retire? You're getting, maybe you want to go and pursue other hobbies in your life. That's kind of the tone that an employer will use. Certainly if the employer is more explicit than that, maybe they've even put something that suggests that they want you to retire in writing. Of course, feel that you should be keeping copies of that, retain copies of that correspondence, because it could be very helpful information if you pursue a case against the employer. Okay, great question there as well. These are all, topics that are super relevant. They're obviously impacting so many Canadians, and I deal with them all the time. So, okay, we got another great question that just came in from Bro on YouTube. My hours were cut significantly, and when I asked about it, my boss said, if you don't like it, you can quit. Okay. So another employer, putting pressure on an employee to quit. Um, don't quit. Don't quit. First, talk to me or someone on my team, because there's a certain, you might want to resign, but it has to be done a very specific way so that you can pursue a constructive dismissal. For those of you who are joining us, just recently, I talked about this notion of a constructive dismissal earlier in this question and answer session. And so remember that what that is where your employer is changing a key term of your employment in a significant way. So as Brobro said, his hours were cut. So if your hours are cut, your hours are a key term of your employment. That's not a small thing. It's a major aspect of your work. And so if they were cut significantly, maybe went from 40 hours a week to 25 hours a week, that's certainly a significant hour cut. If that happens, then you can treat that as a termination, and you can absolutely pursue your severance. But don't just walk off the job. You got to do this in a very strategic, thought out way, and we assist people with that process daily. So contact us again, help@employmentlawyer.ca, and we will help you challenge this and get your entitlements here. Okay. We just got another question coming in from Amy on Facebook. I was given a very incorrect and unfair performance rating based on subjective inaccuracies that my manager came up with. Feels like I'm being managed out. What should I do? Okay, so if you if you feel like the performance rating or the performance review was inaccurate, what I usually recommend to people is that they voice their concerns and put it in writing, and state why you believe that the rating that you got or the comments that you got about your performance are either completely untrue or embellished, exaggerated, whatever the case might be. You want to make sure that you document that. Some employers, if they think that you really are having performance issues, they will terminate you, and they might even go so far as to terminate you with cause, which means without your severance. Now, almost always, if you're terminated for cause without your severance because of a performance issue, the employer's in the wrong there, and they can terminate you perhaps, but they have to give you your severance pay. But in order to try to get ahead of those issues, what you should do in this situation is document your comments, send that in to the employer, and make sure you retain a copy of it as well, so that you can always go back to it, refer back to it, and if it does become a legal dispute, you have that in writing that you challenge the performance rating that you got. Okay, great questions there. Let's see what else we have here. Okay, we got a quick, easy one question on Facebook from Hannah. My employer regularly asks me to work unpaid overtime and says I'm a salary employee, so I don't get overtime. Is that true? No, that's not true. Salaried employees, hourly employees, you're still entitled to overtime. There are certain exceptions where people do not qualify for overtime, which I won't necessarily get into now. But most employees are entitled to overtime pay, and if you're a salaried employee, it doesn't change that. Okay, another good one here on Reddit from Jenny. My employer reduced my pay because I moved to a different city while working remotely. Is that allowed? So that's an interesting one. I guess you work in one city remotely for an employer, then you continue to work remotely, but you move to a different city, and then your employer reduces your pay. I don't know why they would reduce your pay in response to you moving. But if that is what happened, then that if they reduce your pay significantly, then that's going to be another example of a constructive dismissal. Which we've talked about in this session. Your employer cannot just reduce your pay. Your pay, again, another very key term of employment, that you get paid for the work that you do. And if your employer changes that in a significant way, you got to challenge that immediately. You can't let something like that go. You don't want to create a pattern where your employer implemented these things and you just did nothing about it. You have to do something about it. Again, something you want to carry out in a strategic way. So make sure that you get advice from us before you go ahead and challenge the pay cut. But very important that you do in fact challenge it. So let me. I want to touch back on something we were discussing earlier about cause. So what is a termination for cause? I mentioned quickly that termination for cause is a situation where you have been terminated and your employer is saying that they have a certain reason for it, perhaps. And either way, they're not giving you your severance pay. So if your employer is doing that, very, very often, there is not actually cause for termination. Your employer can say that there is cause for termination, but the law, again, may not agree. So if the law does not agree that there's cause for termination, then you can challenge that and you can pursue and obtain your severance pay, something I help employees with all the time. So don't just take it for granted that your employer has said, your performance wasn't good, terminating you without severance pay, or whatever the reason might be. The law sets a very, very high standard for a situation where an employer can actually get away with terminating you and withholding your severance pay. It's not so difficult for an employer to terminate you, right? They can't do so if they're discriminating against you or if they are retaliating against you because of a certain thing that you did. Maybe you submitted a complaint about harassment, for example, and then shortly thereafter you're terminated. The termination itself might be an issue there. But in most cases, an employer can terminate an employee, but they have to pay them the correct amount of severance, which rarely occurs until you get a lawyer involved to challenge the severance pay that the employer has offered you. So this is all to say, you don't, like I said, don't take these things for granted. Make sure that you challenge, make sure that you seek advice and then challenge, if appropriate, the employer on these types of issues. Okay, we got another question here from Kim on Facebook. I was told my job is no longer being funded, and I got notice, I assume notice of termination, for March 14th. No severance. I've been there for 5 years. In August, they gave me 7 weeks of notice and a bonus if I stay until March 14th. Okay, so this is a fairly common arrangement here, where you're given working notice, is what it's called. And then if you stay on, they lump it up with a little bit of an extra chunk of money, a bonus here. So it still does not sound like enough. I mean, I don't know the quantum of the bonus, but I would imagine, Kim, that between the 7 weeks of notice that you got and that bonus, you're still not getting what you're actually entitled to, having been there for 5 years. I'd like to know also your age, which you don't have to share publicly, of course, but that's a relevant factor. I'd also want to know what position you held at the company, how much money you were earning. Those are also relevant factors. And once I have that information, I can tell you very, very quickly what your severance entitlement would be. So please feel free to reach out to me, and I will assist you with understanding what your severance rights are and then pursuing them. Okay. Again, you can contact us at helpanemploymentlawyer.ca. Feel free to tell the team if you want to speak with me, and I'll be happy to speak with you. Okay, before we move on, there is something I want to mention. We talk, so much about severance pay in this session. A lot of these issues, ultimately, severance is a big part of it. And so, how do you know what severance you're entitled to? So, of course, I can help you with that, or someone on my team can help you with that. But we also have a very good resource available called the Pocket Employment Lawyer. As you see on the screen, you can find it at pocketemploymentlawyer.ca. And you will be able to use our severance pay calculator. And you should know the severance pay calculator is anonymous. It's free. And you will be able to very quickly find out the range of severance that you're entitled to. All you have to do is fill in the information regarding your age, your length of service for the employer, how much money you were earning, what position you held, and within a matter of a minute, you're going to get your answer in terms of what your range of severance is. And then once you have that information, feel free to call us, and we'll actually help you obtain that amount of severance. So you don't have to wait, even if you haven't been terminated, but you think a termination might be coming soon, or you're one of the people here today who have posted questions about a constructive dismissal situation. Your pay was reduced, or your hours were changed, or you worked remotely for so long and now you're being told that you can't work remotely anymore. And any of those situations as well, you would be entitled to severance pay. So feel free to use our Pocket Employment Lawyer tool, and you will get a great sense of your range of severance. Again, free and anonymous to use that. Okay. On that note, we have a good question from Sandra on Reddit. Sandra says, my employer has told me that my termination pay is limited to the ESA minimums. Do I have any entitlement beyond that? So very simply, yes, you do. Most employees are going to be entitled to more than just their ESA minimums. Those are just minimum termination entitlements that you get as an employee. And you're going to be entitled to more than that. Again, based on those factors, your age, your length of service, your position, etc. So the one thing I'd want to know is perhaps you have an employment contract, Sandra. If you have an employment contract, that's something I want to review. And then I will tell you if your employer is correct, that you only get your ESA minimums, or I'll tell you what I tell most employees that I speak to, that your employer is not correct about that, and you get more than your ESA minimums for sure. So that was a great session. It was a pleasure to be back with you guys. I'm going to be back here again for another Q&A session very soon. Again, I'm Jeremy Herman. I'm an employment lawyer at Samfiru Tumarkin LLP, employmentlawyer.ca, and I'm located in Ontario. We have another question and answer session coming up soon. Our next one for employment questions will be with my colleague Lior on Wednesday, January 28th at 1 p.m. So tune in for that. And until I'm back with you, take care. All the best.